ಆಯ್ತು ಸರ್, ಟ್ರೈ ಮಾಡಿ. ಬ್ಲಾಕ್ ಕಂಪ್ಯೂಟರ್ ವರ್ಕ್ ಆಗ್ತಾ ಇಲ್ಲ. ಯಾಕಪ್ಪ ಕನ್ಫ್ಯೂಸಾ? ಅಡ್ವೊಕೇಟ್ ಹೆಸರು ಹೇಳಿ ಹೋಗಿ. ಹಾಂ
ಕೊಟ್ಟೆ ಇಷ್ಟೊಂದೆಲ್ಲ
ತಂದವರು ಅಂತ.
ಸರ್ ಜಿ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್.
ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇದ್ರೆ ಆಯ್ತು ಕಂಪ್ಲೇಂಟ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಕಂಪ್ಲೇಂಟ್ ನಾಳೆ 2 days ಅಂತ ಹೇಳಿರ್ತೀವಿ. ನೋಡಿ ಕೊಟ್ಬಿಡಿ ಅವ್ರ ಕೈ.
Premature
suspension
fresh matter.
Maybe tomorrow.
Fresh matter tomorrow kodi. Fresh
Like
matter
one
kodi.
premature
Pending matter.
transfer at 2:30.
Tomorrow. All fresh matters tomorrow. So last shift leave. Fresh matter. Word matter. Yes, 26th. The last
My
shift
lord.
leave.
Compulsory appointment.
Fresh matter. Tomorrow, yes. Fresh matter. Put it tomorrow, yes. Not 2:30, we'll see tomorrow, yes. Tomorrow. What is that cover? Yen covered, what is that issue? Huh?
Subject.
No, what is the subject it is covered, mister? Yen covered ide. No matter has been posted for covered before.
Actually, with your point, one matter.
ಯಾವ್ದು ನೋಡ್ಕೊ ಬನ್ನಿ ಫಸ್ಟ್. ಏನ್ ಸಿಮಿಲರ್ ಯಾವ್ದು ಇಶ್ಯೂ ಹೇಳಪ್ಪ, ಸುಮಾರು ಇದಾವೆ. ನೋಡ್ಕೊ ಬನ್ನಿ ನಾಳೆ. ಎಸ್
One matter post matter immediately after complaints, I have complained it,
Hmm.
court matter and also it's covered by judgment. I'm
26.
going abroad 2 days from midnight and come back 1 day, 1 month.
Hmm.
USA was kindly induct in this.
No, end of the list. Fresh matter.
Not fresh matter, 2020 matter,
Hmm.
last week it came, ವಕಾಲತ್ ಸೈನ್ ಆಗಿಲ್ಲ ಅಂತ.
Hmm.
Post immediately after complaints ಅಂತ ಇತ್ತು, complaints
Yes,
ಮಾಡಿದ್ವಿ.
25th, yes.
My lords,
Matter. Yes. 9th, yes.
My lord, on compensation appointment notice has been ordered.
Hmm.
She is widow, my lord.
Yes, 24th.
In this matter, it's a pending matter. Petitioner is being denied full pension on the ground that he is eligible only for the pension calculated on 40% of his last gross salary. But it is only for the calculation of the start wages number.
Yes.
And it is entirely contrary to the judgment of the High Court.
Yes, 9th, yes.
my lords,
Petitioner has not been paid. He will be covered by.
Yes, 10th, yes.
My lords, this matter is.
Bangalore University notification matter, my lords, it was listed day before yesterday. Your lordships are directed to serve it on the respondents and come. Today is the last day to file the application. There is urgency, it may be taken up today.
Tomorrow, yes.
So today is the last
It's a
day,
pension
my
matter.
lord.
Tomorrow, notice is set. How can that other side come, madam, without that?
I have informed the other side as well, my lord.
Tomorrow, yes.
I request, my lord, end of the list.
No, tomorrow, without that notice. Yes, 25th, yes.
It's a pension.
Yes, 13th.
My lords,
Petitioners was not given pension till date, my lord, any date pending.
13th.
My lord, it is,
Yes, 13th.
my lord, it is pending matter.
RFA.
Next week, any date.
RFA, ತಗೊಳ್ಳಿ ನೋಡೋಣ ಯಾವ್ದಾದ್ರು ಒಂದು. Friday.
My lord, pending matter related to pensionary benefits, my lord.
Hmm.
Is a retired person. Only short date, Monday or Tuesday.
ಆಗಲ್ಲ 10th October, yes.
my lords, this matter is pertaining to fake ITI mass card, my lords. There is an ex parte interim order. We have filed IA for vacating, my lords. There is an urgency, my
Getting
lords.
the file.
It may be taken up tomorrow, my lords. There is an urgency. The writ
No, no,
petition
no.
has become infructuous, my lords.
Why?
My lords, they have challenged the committee report and they have sought for not to dismiss from the service, my lords. But before they filed the writ petition, they were dismissed from the service, my lords. It may be taken up tomorrow.
How
my
it will
lords.
become infructuous?
My lords will argue on merits, my lords. We have
That is
filed
true.
IA
How
for
it will become infructuous? You said it become infructuous. Yes, 23rd.
tomorrow, my lords.
Tuesday.
Grateful, my lords.
Yes.
The last the RFA matter, my lord, of 2014, your lordship. The matter was referred for mediation. It was not settled, your lordship. The petition applied before the Dishonorable Court.
Yes, 26th, Friday.
Yes, sir.
Two matters where interim orders have been granted, but matters have to go before the KSAT. The state is aggrieved because of the interim orders. my lord.
Yes. 24th. Yes.
Great.
24. Adjournments, if any, one adjournments.
Please, my lord, item 48 in list number 1, I'm for the petitioner. We moved the memo to
Yeah,
have
the
this matter.
Being spoken to chamber ಕಳಿಸಿ ಅಂತ ಹೇಳಿ. ಈ post ಮಾಡಿಸ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಇಲ್ಲ, chamber ಗೆ post ಮಾಡಿ. Yes, serial number?
Serial number 48, my lord, 1, I'm for the petitioner. We moved the memo to have the matter listed. The date given by the court was the 24/9.
ನೀವು ಕಳಿಸ್ಲಿಲ್ಲ. Mistake ಮಾಡಿ. Yes, 48, what you are appearing for whom?
For the petitioner, my lord, the date given by the court was 24/9. Accordingly, the arguing counsel would not be available today. If we could have
Yes.
it on the 24th.
We'll have it after 2 weeks, yes.
Could a date be fixed, my lord? There is some urgency in the matter.
Yes,
His promotion
the
has been
request of
withheld.
counsel for the petitioner, read this matter on 9th October, yes.
Lordship, serial number 38, your lordships. I appear for
My
respondent.
lord, my lord, I am for respondent. Yesterday only your lordship has directed to argue today only, my lord.
Which one, 30?
38, your lordships. I appear for R2
No.
and R3, your lordships. We have
Sorry.
informed the other side, your lordships.
38, you are appearing for whom, madam?
No, my lord, 34, sorry, my lord. Sorry, I
38,
apologize.
you are appearing for whom, mister?
R2 and R3, your lordships.
Have you informed?
Informed the other side, your lordships.
At the request of counsel for that respondent number 2 and 3, leave this matter after 2 weeks.
Lordship, serial number 65. I appear on behalf of the petitioner.
Yes,
Today there is some inconvenience, my lords. 10 days time maybe.
at the request of counsel for the petitioner, leave this matter after 2 weeks.
Okay.
57. We have a respondent's counsel.
Yes.
Taken up next week.
Have you informed other side?
Yes, my lord, yes.
At the request of counsel for the respondent number 2 and 4,
Yes, ma'am.
release this matter after 2 weeks.
Serial number 54, my lordship.
Hmm.
2 weeks time.
You are appearing for?
Petitioners.
At the request of petitioner, release this matter after 2 weeks.
Sir, in VC, any adjournments, list number 1? List number 1 for being spoken to, serial number 1, Somashekhara RP for petitioner.
For respondent 3 and 4,
Data of another wife of ಅಂತ ಆಗ್ಬಿಟ್ಟಿದೆ.
ಅಷ್ಟೇ
ಅಷ್ಟೇ ಅಷ್ಟೇ.
ಆದ್ರೆ ಚೇಂಬರ್ ಅಲ್ಲೇ ಮಾಡ್ಬೋದಿತ್ತು. ಯಾಕ್ರಿ ಯಾರು ಕಳ್ಸಿದ್ರು?
ಅದು ನಂದು ಪೆಟಿಷನ್ ಅಲ್ಲೇ ಹಂಗೆ ಆಗ್ಬಿಟ್ಟಿದೆ ಅದಕ್ಕೋಸ್ಕರ.
ನೀವು ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಹಂಗಾಗಿದೆ.
ಹೌದು.
ಮತ್ತೆ ಅಮೆಂಡ್ಮೆಂಟ್ ಹಾಕ್ಬೇಕು.
ಅಮೆಂಡ್ಮೆಂಟ್ ಹಾಕಿದ್ದೀನಿ, ಅದು ಹಾಕಿದ್ದೀನಿ, ಎರಡು ಹಾಕಿದ್ದೀನಿ. 151, 152 ಎರಡು.
ನಿಮ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ನಿಮಗೆ ಡಾಕ್ಟರ್ ಯಾರು ಇದು ಯಾರು ಅನ್ನೋದು
ಅದು
Yes.
type.
Where is your application?
That application.
Correction of cost title and rectification of the office objection raised on IA 2. Yes, Mr. In the petition, it is wrongly typed that wife of, make it as,
Data.
where is that IA for amendment in that petition, Mr.?
But IA one my lord.
Yes,
Amendment of
IA
cost
1
title.
of 2025 is filed for correction of
Cost title.
cost title. Instead of Srimati Savita, daughter of Shivappa, it has been mentioned as wife of Shivappa. IA is allowed. Counsel for the petitioner is permitted to amend the cost title, correct the cost title. Consequently, in the judgment order dated 22nd July 2025, the cost title is also corrected as daughter of Shivappa. Yes. IA 2 ಏನು?
ಒಂದು ಅಮೆಂಡ್ಮೆಂಟ್ 152 ಕರೆಕ್ಷನ್ ಆಫ್ ಜಡ್ಜ್ಮೆಂಟ್ 152
Yes, applications are disposed of.
Sir, amendment.
ಮಾಡ್ತೀನಿ.
Preliminary hearing, serial number 2, Vijay Raghava Sarathi HM for petitioner, BLC.
My lord, kindly pass over, my lord.
Password. Yes.
Serial number 3, Subramanya Bhatt M for petitioner.
Here for the, Lord, this is the post of one Kannada arts, my lord, being treated as excess. Lord, in another petition, my lord were kind enough to grant me an interim order in identical situation. Can I just? In this case also, my lord, the BEO has issued a letter to the DDPA saying that, my lord, it is not an excess post. And my lord, that case was pertaining to one Ramakrishna. My lord, his name is found at page 44 in the writ petition. And my name is, my lord, is also there at page 44.
Or issue notice. Government advocate is directed to take notice for respondent number
1 to 6, my lord.
1 to 6. Issue government for the petitioner is directed to say 4 set of copies. Issue emergent notice to respondent number 7. Stay of annexure.
Annexure E, my lord.
Annexure E in respect of
Renukesh, 7th respondent.
in respect of 7th respondent. Item number 19. Yes, till next date of hearing.
Can I seek for a hand delivery?
Yes, dispensation for a period of 4 weeks.
Serial number 4, Putra Gaudar.
Your Lordship, I appear on behalf of the petitioner, Your Lordship. Your Lordship, here in this case, the petitioner was appointed as junior engineer in Municipal Corporation Hubli dated so and so, Your Lordship. Idrali enagide, Your Lordship, the notification which was issued in Annexure B, his name is in this serial number 2, Your Lordship. Leaving him, other junior cadets were given the promotion as assistant executive engineer, though he's being a qualified cadet to get the promotion, Your Lordship. And there's a writ appeal which is being filed wherein the writ appeal number 1369 of 23 There's a status quo order and court has passed an order that to fill the vacancies in accordance with law, Your Lordship.
Yes, what is this?
There appears to be some error also, my lord, because as per annexure B, there are only 4 posts and as per the impugned order, there are
No, what is
there
that?
were only
Your
3
Lordship,
posts available.
the candidates who have been appointed, they are from backlog quota, Your Lordship. ಅಲ್ಲಿಂದ ಅವ್ರಿಗೆ promotion ಆಗಿರೋದು. They are juniors to the petitioner, Your Lordship. He is the eligible candidate wherein his name was there in the annexure B column 2, Your Lordship. Serial number
Take
2.
notice. Please. Government advocate is directed to take notice for respondent number 1 and 2. Counsel for the petitioner is directed to serve suit sets copies on government advocate. Emergent notice to 3 to 6.
Oblige, Your Lordship.
Serial number 5, PN Anjan Kumar.
Yes.
I'm for petitioner in this case, my lord. My lord, this petitioner is got appointed as Anganwadi worker, my lord. After some time, my lord, the villager has filed an objection to my appointment, saying that I have given the wrong information to obtain the domicile certificate, residential certificate, and for the same, the respondent issued notices to me, my lord. I have given proper reply to the notices, but my lord, yesterday they got removed me from the job, my lord, saying that I given the wrong information to obtain the
ಆಯ್ತು ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿ ಐ ಹಾಕ್ಬಿಟ್ಟು ಅಮೆಂಡ್ಮೆಂಟ್.
ಸ್ವಾಮಿ ಮಾಡಿದೀವಿ, ಆದ್ರೆ I have been removed. My objection, my lord, may kindly be
ಆಯ್ತು ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರೆ ತಾನೇ ನಾವು ನೋಡಕ್ ಆಗೋದು.
ಆಗ್ಬೋದು ಸ್ವಾಮಿ, but after filing of this writ petition, they have removed me from the job. That is
You amend it and made then a part of that writ petition. Then only we can examine.
Please, my lord.
Yes, not in your file. Should be in that court. File an amended
Please,
petition.
please, please. Date may be fixed by Monday, my lord. Within that, I will amend.
Application ಹಾಕ್ರಿ, application ಹಾಕಿ move ಮಾಡಿ. Then we will consider. Yes.
May kindly pass over, my lord. Today only I will file. No, ಬೇಡ ಆಗ್ಬೋದು ಸ್ವಾಮಿ.
Yes, leave this matter after 2 weeks, 2 days. Yes.
2 days, please. Oblige.
File an application, Mr.
Please.
Serial number 6, Devaraj N for petitioner, A Chandrachud.
The petitioner is a mechanic, retired mechanic grade 2, my lords. He attained the age of superannuation, my lords, on 30th June 2025. He was entitled for increment of the next date, my lords. Next day, that is on 1st July. But I have made in similar matters, my lord, the Honorable Supreme Court, my lords, I said, my lord, they are entitled for the increment. I made a representation, my lord, they have to consider the representation in terms of the Supreme Court judgment, my lords.
Yes, Mr. Chandrachud.
What the submissions being made, Your Honor. Later on, that judgment of this honorable court taken in appeal up to Supreme Court has attained finality. Later on, with respect to this increment, as there was a financial crisis for the entire country, the Union of India moved a matter before the Honorable Apex Court. The Honorable Apex Court has modified the order of this honorable court upheld in that particular Supreme Court by the 3 bench judges of the Honorable Apex Court. Relying upon that, this honorable court in a similar set of circumstances has already considered with their rules made down by the Honorable Apex Court, how it has to be implemented, wherein their prayer is with respect to the previous judgment of Muddanmani's judgment, where that has been clarified. If your lordship is pleased to take to that particular para where this honorable court, considering that, has disposed of the batch of writ petitions, the same similar nature prayer, Your Honor.
Entitled for the enhanced pension prior to 2023.
Yes, my lord.
Yes.
ಅಷ್ಟೇ ಬರೋದು ಅದರಲ್ಲಿ. We are ready to accommodate with that, and that judgment cannot be now looked into where there is a division 3 bench judgment of the Supreme Court which has clarified from which date it has to be considered.
My learned friend, I think, has not gone through the file. I have retired two months back. I have only entitled from this date only. That is for 2 months back I have retired.
Really, Supreme Court says.
I have produced these judgments, my lords. All the Supreme Court judgments I have produced. My lords may kindly produce annexure K.
No, you are working as in a what?
Mechanic, my lords. Mechanic grade 2, my lords.
You have retired for after completion of 62 years.
No, yearly increment, my lords. My lords, I have retired on service, my lords, on 30th June 2025. On next year, 1st July 2025, I was entitled for service since I have completed 365 days of service. 1/7/2025. What Supreme Court has said, my lords.
1/7/2025. But it has to be treated as in a 1 year.
Yes, my lords. Where is the Honorable Supreme Court, my lords, wherever, my lords, cases were pending, in that matters, my lord, the Honorable Supreme Court has said From 1/5/2023, they're entitled for arrears. Before that, they are not entitled in pursuance of Mudin money judgment. Since I have retired now, my lords, I am entitled for increment.
He is wrongly interpreting what the Supreme Court says. The Supreme Court says that to consider an increment, those persons who had retired prior to that particular judgment passed by Mudin Mani's judgment, and where the litigations were pending and who had made a representation, they will not be entitled for the back. They'll be entitled from the date the Supreme Court has clarified the order, not from the date where the Mudin Mani's judgment, which was they're all seeking with. This person retires later on. So when the increment aspect, how it has to be taken is as per the regulations now, Your Honor. His representation is there. Our only grievances will consider his representation, not with the prior what he has makes in the representation, in par with the judgment of the Honorable High Court of this Honorable Court in Mudin Mani's judgment. We'll have to consider as per the regulation now.
No, we'll say consider in accordance with law.
Yes, my lord.
We are not say that how it has to be.
Yes, my lord. That's it.
If you consider wrongly, then you challenge.
Then it will be for him to come back again.
Yes.
My only respectful submission is he says that annexure K, where his representation, he makes the representation, consider me in par with the judgment of this Honorable Court in Mudin Mani's judgment. Annexure K, Your Honor. 55. Annexure F, sorry, my lord. Annexure F, page number 55. Second para, if your lordship say, hence I request your good sir to kindly grant one annual increment in terms of the division bench judgment dated so and so, passed in the case of so and others, and subsequent judgments, and further to refix the retirement benefits, including one annual increment, and further refix the pension. This para we are agreed with, Your Honor.
No.
If your lordship says that
he has right to seek everything. You have right to decide in accordance with law.
Okay, what happens is that if your lordship says if your lordship's direction is there, consider in respect to this. Tomorrow we will be put to a wrong footing.
No, we'll say consider in accordance with law.
Yes, ma'am.
He may say that given a palace, it is for you to decide whether palace can be given to him or not.
If the Honorable Court says that,
Yes,
consider
yes.
along with this representation, and we will be agreed with. In accordance with law, as per the regulations, we will definitely consider it, Your Honor.
Yes, in this writ petition, petitioner sought following relief. Petitioner was working as a mechanic grade 2 in First Respondent Corporation. When did you attain
30th June 2025, my lords.
30th June?
2025.
He attained superannuation on 30th June 2025.
Yes.
Thereafter, petitioner has submitted a representation annexure F, seeking for a grant of one annual increment. Annexure F dated 14/7/2025. The respondent representation has not been considered by the respondent. Hence, petitioner is before this court. Learned counsel appearing for the respondent submitted that if this court grants some reasonable time, representation submitted by the petitioner wide annexure F will be considered in accordance with law. In view of the above, without expressing any opinion on the merit of the case, who has to consider? Only one respondent, huh?
First respondent, my lords.
First
There are two
respondent
respondents.
is, huh?
First respondent has to consider.
Both respondents it can be.
Respondents are directed to consider that representation submitted by the petitioner annexure F dated 14/7/2025 in accordance with law as expeditiously as possible, not later than, which is how many days will take?
3 months.
Within 3 months from date of receipt of copy of this.
And let it be made clear that if the judgment what he is relying upon.
No, I am not saying that he may rely, mister. It is for you to consider, yes.
Serial number 7, Nandini BS for petitioner.
Yes.
Appearing for the petitioner, my lords. This matter pertains to declaration of probationary period, my lords. This is the second round of litigation, and in this present petition, I am seeking this honorable court to quash the communication dated 6/8/25, which was issued by the second respondent, my lords.
What is this annexure, madam?
Annexure D at page number 67 to 68, my lords. My lords, what happened, my lords? The petitioner had obtained her MA degree at KSOU University, my lords, through distant education. And on 2020, after following the due selection process, which was conducted by the KEA, she was appointed as a guest lecturer post, my lords, at Government PU College, Vanutavi. Even after, my lords, our probationary period was not at all declared after serving 2 years of service, and the PU Education Board has issued a notice seeking our explanation why our appointment should not be cancelled on the ground
Matter
of
should go before
non-issuance of
KSAT.
genuineness certificate, my lords.
Matter should go before KSAT.
You are working
According
there,
to her,
madam.
she is appointed in a
No, my
government
lords.
PU college.
Kindly permit 5 minutes time, my lords. I'll bring facts of this.
No,
case.
first he is raising that maintainability. If it is maintainable, then he will go to.
But this is the second round of litigation.
No, I
my
am
lords.
asking you, answer my question.
Please, my lords.
Yes. Are you in a government school teacher?
Please, my lords. I'm working as a
then-
lecturer, my lords.
Then you have to go to that lecturer in where?
Government PU College, Honutagi, Bijapur, my lords.
Then you have to go to that KT.
My lords, the matter is simple, my lords. Our probation, our genuineness certificate was not issued by the KSOU University. That's why the PU Education Board has not declared the probationary period of petitioner, my lords. And now the PU Education Board has issued another notice to cancel her appointment, my lords. After serving 5 years of service, my lords, now they have issued this notice removing her from service.
I
my
think you
lords.
go and raise this issue before that KT itself. That is that preliminary objection raised them. Yes. But outside government advocate has raised an objection that.
My lords, kindly have this matter tomorrow, my lords.
Why?
I'll seek instructions, my lords.
Yes. Passor.
Please, my lords.
Passor will get. Yes.
Serial number 8, Prithvish MK.
Let's appear for the petitioner. Let's challenge the government order.
Yes.
Let's, I'll just take your lordships through the facts. Let's a private dispute between two sets of parties, page number 38, my lords. Relevant portion is at page 40, my lords.
You are not in a government servant.
He's retired employee. I'm a retired employee.
And also you have to-
17A, my lords. Some permission is granted under section 17 of prevention of corruption.
ಯಾಕೆ ಹೋಗ್ಬಾರ್ದು ಅಲ್ಲಿ?
Prosecution tribunal jurisdiction illa, only in respect of service matters. This has got nothing to do with service conditions.
Then how can you classify this as in a service? Then?
My lords, we informed the registry, my lords. They said we classify all matters as service. My lords, if your lordships will not, I don't. It is not touching upon my service conditions at all.
Yes, then it has to go to the GM.
But
if it is service, then it has to go to that KT.
KT. My lords, but
Yes,
registry told
council for
some
the
urgency, my lords, tomorrow.
Yes, submitted that. The government advocate has raised a preliminary objection regarding that. Since petitioner is holding in a civil post, he was in a retired civil servant, he has to approach KT. Learned counsel appearing for the petitioner has submitted that. In this writ petition, he is not seeking any relief in respect of his service condition. Therefore, office has wrongly classified this as a service matter. Hence, office is directed to reclassify this matter and post before appropriate roadside bench. When do you want? Huh? Yes. Yes.
It's either GM or 482, either of those. So it can't be service.
Yes. Yes. ಎಲ್ಲೋ ಐತೆ ಅದು ಜಡ್ಜ್ಮೆಂಟ್ ಅದು ನಿಮಗೆ ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಟ್ಟಿದೆ ಅವರಿಗೆ ಅದನ್ನ ಇಸ್ಕೊಳ್ಳಿ ಅದು. Yes.
Oblige.
Yes.
Your lordship may not mistake us. Not that we don't want to.
No. There is a one of the matter.
Yes.
When it is filed before that GM court, that has directed to classify service. That's mistake. Office ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಹಂಗಾಗಿ ಹಿಂಗ ಆಗ್ತಾ ಇದೆ. Let us see that. Therefore, I have record your statement that it is not in respect of your service condition. Tomorrow, yes.
Oblige.
Serial number 9, Sundara Raman ME for petitioner.
NMC regulations below.
Yes.
Earlier, before 2017,
yes,
a senior resident could be appointed from a diploma holder.
Yes.
In 2020,
yes,
2017 to 2020, they said senior resident cannot be appointed from diploma holders.
Yes.
2020, they again permitted appointment from diploma holders. So I was a diploma holder. I became a senior resident. Now in 2025, there was no promotional avenue at that point in time to assistant professor. Now in 2025, they've allowed promotion to assistant professor. But they've said only if you're a senior resident prior to 2017.
Yes.
Now there's no justification to fix a cutoff date, because if I'm a diploma holder, my lord, whether it is prior to 2017 or in 2020, diploma holder remains a diploma holder only. Today, therefore, I am not being considered for my promotion to assistant professor, though I have completed 4 years.
Now, what is the rule says?
Yes, Your Lordship may kindly see the rule. Please see at page 40 is the regulation,
Yes,
the qualification regulation.
yes.
The promotion not to assistant professor is at page 57.
Yes.
My lord will kindly see assistant professor there. Then at the bottom, my lord, who all can become?
Yes.
D. Diploma holders appointed as senior residents in a recognized medical institution before 8/6/2017, having total experience of 4 years as senior resident. Now they fixed 8/6/2017.
17.
The regulations prior to 8/6/2017 allowed diploma holders to become senior residents.
Yes.
After 8/6/2017, they said only PG or DNB
Yes.
can become senior residents.
Yes.
That they changed in 2020. In 2020 regulation, Lord, kindly see is at page 76. Page 74. 12th February 2020.
74.
Page 74.
Yes.
To become a senior resident is at page 76.
Yes.
The qualification is a postgraduate qualification MD, MS.
Here where you are reading
Bottom, Lord, just above super speciality.
Yes, yes.
So senior resident.
Yes.
A postgraduate qualification MD, MS, DNB or diploma
Yes.
in the concerned subject. Therefore, what was there prior to 2017 was reintroduced in 2020.
Yes.
Therefore, I became a senior resident in 2021. Now, Lord, in 2025, they say, so I have 4 years experience
Yes,
now, Lord. Now, in 2025, they say, only if you are a senior resident prior to 2017, you can be considered for assistant professorship. That can't be. You can't create an invidious discrimination between a person who has become a senior resident in 2017 and in 2020 I was qualified.
Yes. Now, what is that?
I have therefore challenged that regulation fixing the cutoff date.
Yes.
That cutoff date couldn't have been fixed, Lord.
Yes, you take notice.
Yes, Lord. May I serve Mr. Keti, I think, for NMC?
Yes, so and so is directed to take notice for respondent number 1. Who is there for
Union of India, I have served, Lord.
Served.
Memo of
Deputy
appearance also I have.
Solicitor General is directed to take notice. Shanti Bhushan, directed to take notice respondent number 2.
Only problem, my lord, is they are making other promotions
Yes.
to the position of assistant professor.
Yes, you serve it, we will have it on 24th.
24 in
Yes.
the preliminary hearing list.
Yes.
Yes.
Is this matter 24th in preliminary hearing list? Yes.
I'm great.
Dispensation.
Dispensation for a period of 4 weeks.
Serial number 10, PN Nanja Reddy for petitioner.
The petitioner is senior to respondents 3 to 5. That their case has been considered and promotion order has been passed annexure N. That seniority list mirrored page 131.
Which department?
Mirrored KPTCL. Now they have been promoted mirrored annexure N. 38/2025.
Who has been promoted?
Respondents 3 to 5. That seniority list you lost my kind page 131.
131.
Yes, Lord. First name is mine.
Your name is not considered.
No, my name is not considered.
Why? Is there any D is pending?
D also mirrored exonerated. Despite of that,
Yes, you take notice.
Chandrachud.
Issue emergent notice to respondent number 1 and 2.
3 to 5.
1 and 2 are there.
Chandrachud. Blood.
Tantara? Yes, Chandrachud is directed to take notice for respondent number 1 and 2. Counsel for the petitioner is directed to serve 2 sets of copies. Issue emergent notice to 3 to 5. Yes.
Dispensation.
Dispensation for a period of 4 weeks.
For 11, Prithvish MK for petitioner.
Let the petitioner, my lord, is work. Let annexure E, page 23, my lord, is the order of promotion, my lord. Annexure E, page 23.
Yes.
My lord, I was promoted as fitter grade 3, my lord, in 2020. Now,
Yes.
my lord, at page number 24, my lord, they say they have made a working arrangement and I am posted to pre-treatment plant painting production, my lord. They say as a fitter. My lords, cadre and recruitment rules, my lords, does not have post of fitter in painting department, my lords.
You are appointed as what?
Fitter, my lords.
Fitter.
Yes, my lords.
Now we
ಈಗ
have been,
painting departmental fitter ಅಂತ ಕಳ್ಸಿದೀನಿ ಅಂತ impugned order.
where is that annexure?
Annexure F, page 24, my lords.
24.
Let's, in painting department, there's no post of fitter, my lords.
ಕಂಪನಿ ಆಡಳಿತಾತ್ಮಕ ಅಗತ್ಯತೆ ಮುಂದಿನ ಆದೇಶವು ಈ ಕೆಳಕಂಡ ವರ್ಕಿಂಗ್ ಅರೇಂಜ್ಮೆಂಟ್ ತಕ್ಷಣ ಜಾರಿಗೆ ಬರುವಂತೆ ಆದೇಶಿಸಿದೆ. ಶ್ರೀ ಶಿವಾನಂದ ಸೋನ್ಸು ಫಿಟ್ಟರ್ ಗ್ರೇಡ್ ಮುದ್ದೆ ಎಲ್ಲಾ ಕರ್ತವ್ಯ ಜವಾಬ್ದಾರಿ ನಿರ್ವಹಿಸಲು ಸಂಧಿ ಉಪ ಪ್ರಧಾನ ಮಾಡಿಕೊಡಲು. In that C&R rules there is
department, my lord. Like some dispute, my lord, private dispute between the deputy manager and this person, my lord.
Yeah.
Now I am made to work as painting helper, my lord, which is a non-technical post, my lord, 1 grade.
issue notice stay of annexure F till next date of hearing. Issue emergent notice.
Obliged. Dispensation.
Dispensation for a period of 4 weeks.
Number 12, Satish K.
Yes.
The petitioners are before 8/2018. Lord, notification is issued by the Lord BWSSB to fill up the post of Lord assistant engineer. Petitioners have applied to the post of assistant engineer
Yes.
pursuant to the notification dated 24/8/2018.
Yes.
Lord, private respondents, Lord, 2 to 7 were also, my lord, assistant engineers
Yes.
applied, my lord, pursuant to the subsequent notification dated 27/2/2019. My lord, our notification is dated 24/8/2018.
Where is that?
Lord, annexure A, my lord. 24/8/2018 is the notification issued pursuant to which we have applied.
Yes.
Lord, their notification is annexure C, page 58,
Yes.
dated 27/2/2019, after about, my lord, 6 months.
2019.
Yes, my lord. 27/2/2019 is their notification.
Yes.
Our notification is dated 24/8/2018.
Yes.
Lord, unfortunately, my lord, our notification did not culminate in, my lord, the selection list. They were appointed at first.
No, that is it superseding that 2019?
ಇಲ್ಲ ಇಲ್ಲ, ಬೇರೆ ಬೇರೆ notification.
ಬೇರೆ ಬೇರೆ
ಬೇರೆ
notification.
ಎರಡು separate notification. But assistant engineer ಎರಡೂನು. Lord, though our notification is prior to their notification, they were appointed earlier. They were appointed earlier, my lord. My lord, they were appointed in, my lord, BWSSB on 23/11/2021.
Yes.
Lord, we were appointed on 29/9/2023, but after 1 year. Now, my lord, seniority is given to them on the ground that they have been appointed.
On basis of their appointment only.
Yes, my
How can you say that your notification is early?
Earlier.
You have not been appointed early.
No,
You would have challenged their appointment order. You have not challenged that.
We have not challenged.
Then
Lord, in respect of, my lord, 1998 and 1999 gazetted probationers, Lord, this honorable court has held that.
yes. Their appointment order has been issued.
Yes,
What is that judgment?
Lord, the division bench says that, my lord, because of there is no fault on the part of the employees concerned, then, my lord, if there is delay in issuing the appointment order, the persons who are appointed prior to the appointment of the private respondents, then, my lord, they are required to be treated as seniors.
No, that their appointment order has been challenged here.
No, my lord.
Then seniority list has been
Seniority list was challenged.
Where is that? Any dispute regarding the seniority between the direct recruitees and promotees? This is direct recruitees and promotees.
Two direct recruitees, my lord. My lord, the issue is framed.
The vacancies are others when that notification is issued. The recruitment process has begun when it re-enters.
Second issue, my lord.
The direct recruitment is started to the vacancy
Nagaraju was
Delay in
state.
direct recruitment process. In the meanwhile, the promotions are given.
If there is delay in, my lord, recruitment of the first notification,
No, there, before recruitment process is completed or delay in recruitment, the promotion has been given.
yes, ma'am, promotion is given.
Therefore, no, here, one set is they are promoting, one is direct recruitment.
Ibruno direct recruit is.
ಎಲ್ಲಿ
ಇಲ್ಲಿ
ನಿಮ್ ಕೇಸಲ್ಲಿ
ಹಾ
ಇಲ್ಲಿ ಒಂದು ಪ್ರಮೋಷನ್ ಒಂದು
ಇಲ್ಲ
direct
ಇಲ್ಲ ಇಲ್ಲ
recruitment.
ಎರಡನ್ನೂ ಡೈರೆಕ್ಟ್.
See,
I don't have the copy.
when the test is when the direct recruitment is appointed to that vacant post. If there is any delay in direct recruitment process, and in the meanwhile, promotions are given, promotees are appointed to that said vacant post.
Next issue, my lord, not that issue.
Thereafter, direct recruit is.
There are three issues, my lord. Next issue, my lord. Between two direct recruitment.
Order passed by the Karnataka Administrative Tribunal was placed held in the absence of any rules providing the fixing of inter-alia seniority. Two different notification merely because there is no specific rule injustice that would cause to that real test is if well-established rule is departure, whether that would be consistent Article 14 when there is no rule cannot be insisted upon. What is to be seen is that such a circumstance departure from the general rule is valid to protect that interest of the person to be appointed in pursuance of the notification is made. Let us see, you take notice. Government advocate is directed to take notice. Government ilva?
Lord, Mr. B.L. Sanjeev may be directed to take notice for R1.
B.L. Sanjeev is directed to take notice for R1. Emergent notice to?
R2 to R7.
R2 to R7. Yes.
Lord,
What has happened now? They have been promotion, seniority they have been placed.
Lord, in the Lord, in the impugned, I have challenged the impugned seniority list. Lord, they have been placed above. Lord, we have been shown as per the appointment order.
Yes.
Lord,
They are not giving any effect to that promotion.
Lord, they are considering their case for promotion to the post of Lord.
My lord, B.L. Sanjeev, take note.
You take notice. We'll have it on 25th. Verify what is this judgment. Copy ಅವರಿಗೆ ಒಂದು ಕೊಡಿ judgment. Verify that judgment. Dispensation for a period of 4 weeks.
Lord, Lord, matter may be listed in preliminary hearing.
In the preliminary list on 25th. Yes.
For the petition. Not, so these are matters similarly placed to that of the matter that had been decided the day before yesterday, my lords.
What is this?
They are assistant linemen, my lords, who had been appointed in the BESCOM department. There is an order of this honorable court which came to be passed, my lords. I draw the attention of this honorable court to page number 236, my lords, annexure K, dated 26 April 2025. Order of this honorable court came to be passed.
236.
Yes, sir. 236 is the beginning page, my lords. The operative portion is at page number 260. 260, my lords.
Yes.
There, the question was that, my lords, the writ petition came to be allowed. Thereby, my lords, setting aside the disagreement note as well as the termination order which came to be passed, thereby calling upon the department to comply strictly with Kunj Bihari Mishra's judgment. And they have to first provide the conditions for
where
disagreement.
is that observation?
Observation, my lords, it's at page number 260, my lords. WP number 12037/2025, which concerns the petitioner in this case, is allowed the impugned orders bearing number so and so and so and so of event date. That is 3/4/2025, passed by respondent number 4, terminating the services of the petitioner.
Submits that. In earlier occasion, this court has quashed that inquiry report.
Yes, sir.
Inquiry report.
Not inquiry report, my lords, the termination order, which came to be passed against me. And
Yes.
now there is a show cause notice quite contrary to Kunj Bihari Mishra's judgment.
Quashed that. Number 12037 of 2025. You are also party in that.
Yes, please, my lords.
In connected matter. And remitted the matter back to that respondent to issue fresh notice informing the petitioner about the reason for rejecting the report of the inquiry officer. Thereafter, proceed in accordance with law as held by Honorable Apex Court in the case of Punjab National Bank and other sources, Kunji Bihari Mishra, 1998 7 SCC 84. in spite of that direction, without giving any notice to the petitioner.
Notice has been now given.
Notice is
Which,
given now.
Which the disagreement
challenged.
note is not there, my lords. The notice
That's
is
what
under
that
challenge.
remitted back to that without giving any notice, informing the petitioner about the reason for rejecting the report.
Reason for disagreement. Reason for disagreement, they propose that
Yes,
I have
reason
been,
for
I have provided
disagreement.
fake marks card.
Reason for disagreement for not accepting the report
Yes.
without giving in a notice for reasoning for disagreement for not accepting the report as per the directions of this court. The impugn order has been passed. The same is contrary to that directions issued by this court. In view of the above, the impugn order annexure.
Annexure M, my lords.
Annexure M.
M1 and M2.
M1 and M2 is stayed till next date of hearing, reserving liberty to the respondent to file application for modification or vacating the interim order.
It may be connected with the other petition, my lords. That
Call this matter along with that 28342 of 2025.
27982, my lords. I have provided with a memo, my lords.
28342.
That is the memo, my lords, in this case. I draw it to
27982 of 2025.
14 also same. 14.
14 also same.
14 also the same.
Same in 14. Government advocate is directed to take notice for respondent number 1. Issue emergent notice to respondent number 2 to 4.
Their impugn annexure is P to P4, my lords.
Other will P to P4.
Yes.
Dispensation for period of 4 weeks. Call this matter along with its own.
Memo for hand delivery.
Yes.
Cell number 14 adjourned, cell number 15,
For
Prasanna
the
VR.
petition in this case, my lords. The petition is a professional doctor, my lords. Not a qualified doctor, not appointed as an associate professor at Atal Bihari Vajpayee Medical Institution and Research Center. Lord, in the year 2023.
Yes.
Lord, she is become in charge HOD as there is no regular HOD appointed. But while she was serving, my lord, she was issued with an information as annexure A, my lords, constituting a committee of inquiry against the her on the complaints received by the government. Lord, she was asked to attend the inquiry committee, Lord, without serving any copy of the complaint and charges leveled against her, and she is made to face the inquiry without any document. And my lords, when she was asked to attend on 8-9, my lords, she attended the inquiry and she was questioned, my lords, unnecessary questions, and her mobile were also taken by the committee. On notice, my lords, by notice.
So you are working in which
Lord,
department?
I am working, my lords, in Atal Bihari Vajpayee
Atal Bihari Vajpayee Medical
Institutions, where, my lords, there are students, my lords, who are studying post-graduation in Bangalore Medical College and Research Institute also, because there is no staff in the Atal Bihari Vajpayee Institute, to whom I have to guide. Lord, I have instances to say that some of the students were compelled to make a statement against me by the inquiry committee, not during the course of inquiry, outside the inquiry.
This inquiry committee is constituted under which provision?
Lord, there is nothing is appearing. Yes.
Lord, may I make one request, Lord? This has, I think this is a preliminary inquiry to be conducted on the allegation made by the petitioner here in Milord. After that, they may be issued that charge sheet and so.
Preliminary inquiry, report
ಅದೇ ರಿಪೋರ್ಟ್ ಹಾಕಕ್ಕೆ ಇದು ಮಾಡಿತ್ತು.
I should be made aware about the complaints, my lords. Otherwise, I cannot face the inquiry.
No, this is like an.
Yes, sir.
May I read what it says? Annexure A, my lord. Atal Bihari Vajpayee ವೈದ್ಯಕೀಯ ಮಹಾವಿದ್ಯಾಲಯ ಹಾಗೂ ಸಂಶೋಧನಾ ಸಂಸ್ಥೆ ಬೆಂಗಳೂರು ಇದರ ಅಧಿಕೃತವಾಗಿ ಘೋಷಣಾ ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ಒಬಿಜಿ ವಿಭಾಗದಲ್ಲಿ ಪ್ರಭಾರ ವಿಭಾಗದ ಮುಖ್ಯಸ್ಥರಾದ ಡಾಕ್ಟರ್ ದೀಪಿಕಾ ಅವರವರ ವಿರುದ್ಧ ಸ್ವೀಕೃತವಾದ ದೂರುಗಳ ಬಗ್ಗೆ ಪರಿಶೀಲಿಸಿ ತನಿಖೆ ಮಾಡಲು ಈ ಕೆಳಕಂಡಂತೆ ತನಿಖಾ ಸಮಿತಿಯನ್ನು ರಚಿಸಿ ಆದೇಶಿಸಿದೆ. This is the committee which is constituted for that inquiry, my lord.
Conducting inquiry.
ಹೌದು.
Where is that, which is that law which for conducting an inquiry under all?
Lord, may I make one submission, my lord? The appointing authority who has made an inquiry committee, my lord. For that, there is no, the authority is required because there is an allegation against the petitioner that they want to clarify whether the allegation are genuine or one. If it is find out that the genuine one, my lord.
See, if there is an allegation, if you want to constitute that, this is like in a departmental inquiry you are doing, where is that law?
Lord, may I make, this is not a departmental inquiry, my lord, only the professors were appointed for that reason.
No, where is
ಯಾರ್ಯಾರ್
that?
ಯಾರ್ಯಾರ್ನ ಮಾಡಿದ್ದಾರೆ ನೋಡಿ.
Where is that, mister? You can appoint that professor for your own this thing. Rule has to be provided. Which is that power for you to do all these things?
ಇಲ್ಲ ಇವ್ರನ್ನ ಅವ್ರ ಆಫೀಸ್ ಅಲ್ಲಿಂದ ಮಾಡಿಲ್ಲ, ಅವ್ರ ಕಾಲೇಜಿಂದ ಮಾಡಿಲ್ಲ.
ಇಲ್ಲ, ಡೈರೆಕ್ಟ್ ಆಕ್ಸೆಸ್ ನೋಟ್ಸ್. ಕೈಂಡ್ಲಿ ಸಿ OBG ವಿಭಾಗ BMCRI Bangalore Medical College has a direct access of the facilities provided by the Atal BRI because we have no staff notes in the.
This is a government order, mister.
Yes, government order. That is why notes I have
challenged. Government order has passed.
Yes.
This is not that government wants to conduct an inquiry.
No, government wanted to conduct an inquiry.
Not in a circular.
No, it is a notification.
No, executive order, it has been issued in that name of the governor, mister.
Yes.
It's only committee is constituted to inquire.
There is no rule for them to conduct an inquiry.
Lord,
if there is any statutes covered by a field, you can't exercise that by executive order. What is the law which is provided?
Lord,
See, when there is any statutes,
out.
You can't issue any executive order. If there is no field is covered under the statutes, you can exercise under 162. You cannot be. This is an executive order in the name of the governor.
Yes. Lord, may
then if it is in statutes, you can't override the statutes, mister.
No, this is only in respect of preliminary inquiry, Lord. This is not a final
inquiry. Is there
inquiry.
any statutes?
Idu disciplinary inquiry alla idu.
Disciplinary inquiry statutes will provide madidre, you cannot pass in a government order. You have to do it under the statutes. It is a legislation, mister. When there is any legislation covering the field, Lord, you can't exercise that power under that executive order.
These institutions were independent institutions which constituted under the Society Registration Act.
Aitre idik ಏನು rules law ಏನು ಇಲ್ವಾ ಅವರಿಗೆ inquiry ಮಾಡ?
For the internal inquiry, that is rules is not required, Lord.
Is there any rules, mister? Is there any rules, provisions to conduct an inquiry? If there is any rules provision, then you cannot exercise that executive order.
That I will see that
this employee, if they have committed any mistake, how inquiry has to be conducted?
Lord, in all medical colleges, they have adopted the KCSR, Lord. That is no doubt, Lord.
Then if it is KCSR, there you cannot deviate.
No, Lord, may I request? This is not an inquiry which is conducted under the.
You can't do whatever your fancy, mister. This is a rule which has been made to the employee to conduct a certain procedure. You can't, deviate that rule for each employee's your own whims and fancies. Do it. When there is no rule or act or provision, then you can do it. Otherwise,
that I will show there is a preliminary inquiry, Lord. It has to be conducted by an authority.
No, you get that. Which is that? You ask that. Which is the rule?
Yes, till then, Lords, kindly, kindly.
Or it may be taken.
Lords, two of the members, Lords, are direct access to our institution because the Atal Bihari Vajpayee institution, Lord, has no sufficient staff. Therefore, under the government order, the employees of Bangalore Medical College are deputed to perform the duties. I am the guide to those.
You are in a deputation from.
No. I am a direct recruiting to the Atal Bihari Vajpayee institution.
You are bound by that rules and regulation of the.
True. However, kindly see annexure A, two of the. I may not have any objections to constitute a committee consisting of officials of different college, not this college, because there is overlapping work. BMRC college has not.
No, let us see first where is the power for them to constitute.
Yes. Till then, they.
Tomorrow.
Till there is every possibility of submitting a report adverse because the other day, when I was forced to appear.
If it is only they are submitting in a report.
Yes.
Thereafter, they want to initiate that inquiry in accordance with that rules. Then there is no problem for you. You can be explained there whether they are going to take an action on the basis of this committee report itself.
Kindly
then
see the recital, my lords, Virudha Svikritavada
No, let
Durugala
them-
Bagge. I have not been provided with any of the.
No. If they say, if it is only a preliminary inquiry to get any
Yes.
information or sources to initiate that departmental inquiry, then departmental inquiry has to
My
be
lord, I
followed.
requested the committee, my lords, to furnish the documents.
No.
Lords,
If, let them say it is only a preliminary inquiry to get any information, you need not
my
hurt.
lord, let them, my lords, that observation may be recorded, my lords. Otherwise, I will be, my lords, in trouble
I am
tomorrow.
asking if that will
Lord,
be
if it is a
recorded and
preliminary
close it,
inquiry, my lords, if it is a
then you will close it. It
Lords.
is preliminary inquiry, you will record his statement and close it. That.
Alla,
If you want that.
alla,
If they want to initiate that departmental inquiry, they will follow all
ಇಲ್ಲ
procedure.
ಯಾಕೆಂದ್ರೆ government has no authority to constitute these persons not who are not employed in other college which is having a overlapping work in my college not
Lord, may
where
I
I have
make
been
one,
working.
may I
Lord.
make one submission, my lord. Even otherwise not considered to be an inquiry or something else. Lord, once the notification is issued, my lord, he has himself has accepted that and appeared before that committee. Then he doesn't
No,
have any right
otherwise
to make a submission.
otherwise not I
That is not
ಅದಕ್ಕೆ ನಾಳೆ ನಾನು ಹೇಳ್ತೀನಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀನಿ.
tomorrow. Yes. You want that it is in a preliminary
ಅಲ್ಲ
inquiry, I will
till
record
then
it.
not till then
26/8
not
ಗೆ
to
issue ಮಾಡಿದ್ದಾರೆ.
precipitate otherwise not
Tomorrow.
ಆಗ್ಬೋದು
Yes, otherwise I will record that it is a preliminary investigation. You will be given notice when there is a departmental inquiry. I will dispose of it. Yes. Is this matter tomorrow?
Office of Election, first time matter, serial number 16, Govardhan S.
Your Lordship, I am appearing. A week's time may be granted, Your Lordship.
Yes. Is granted to.
Serial number 17, Jayalakshmama KB.
Covered by judgment, my lord, this is annexure E, my lord. Only two objections, my lord.
To complaint, madam.
Today itself I will come.
Pass on.
Please.
Serial number 18, Vaishali Hegde.
Yes.
Compliance will be done till the course of the day, your lordship.
Yes, pass on.
For
We'll
orders,
have to take the file from here.
Yes, they will give it. Yes. Only after compliance we'll see that. Yes.
for orders, serial number 19, Harish Kumar separate matter.
ಅಲ್ಲ ಇದರಲ್ಲಿ ಲಾರ್ಡ್ಶಿಪ್ಸ್ ಮೇ ಸಿ ಲಾರ್ಡ್ ಐ ವಿಲ್ ನಾಟ್ ಇನ್ಸಿಸ್ಟ್ ಆನ್ ದಟ್ ಅಪ್ಲಿಕೇಶನ್ ಎಟ್ ಆಲ್ ಬಿಕಾಸ್ ಇದು ಸುಮ್ಮನೆ ಗಲಾಟೆ ಅದು ವಾಟ್ ಐ ಹ್ಯಾವ್ ಸೇ ಐ ವಿಲ್ ಜಸ್ಟ್ ಕ್ಲಾರಿಫೈ ಲಾರ್ಡ್ ವಾಟ್ ದಿ ಇಶ್ಯೂ ಇಸ್ that application that I have filed is for lord the maintenance expenses, not rent. That is what lord my clients now clarify to me. Rent I cannot ask because your lordships will see the order dated 16/7/2015. It says, my lord, that an application was filed on 16/7/2015. Lordships may see the order. I just wanted to clarify, my lord, in his benefit also.
16/7/20.
Yes, 2015, my lord. 2015. Adralli, I think, my lord, it is also, it was observed that bench that acceptance of rent after the termination of tenancy would lead to a situation where the relationship is continued and thereby there is a waiver of termination notice. But having also noticed that there was a judgment of so and so where such receipt of rent was not found to be, and therefore it was observed by the bench that though there is no determination of any such damages for use of occupation, measure of rent shall be treated as damages for use of occupation.
No, this is only damages. Court has clarified.
Allah, idralli, I am even saying, my lord, page number 13 of my application, it is not even rent. Rent he has not paid. There is no dispute.
Rent has paid.
He has not paid. There is no dispute. I'll just complete.
No, I am filing memo of calculation, my lord.
Maintenance amount is also not paid. Lordships may see, my lord, that no memo.
See, what the court during that occupation pending of this petition.
Yes.
He has to pay that damages.
Howdu.
Damages cannot be calculated.
Yes.
Therefore, rent will be treated as in damages, whatever the rent.
That he has not paid. There is no dispute. What I am saying
there
is,
is a
Lord,
dispute. No.
let him not interject. I am saying there is no dispute on that. That anyway, my lord, the calculation is there before your lordship. The other is from 2012 onwards. What I have filed now in the application dated 18/7/2025 is maintenance, water and electricity charges on actuals.
No, that will
Adu
come,
kottilla.
no, that will come later.
Yes.
I want to see that whether this court order is complied or not. First.
That's all.
When the court said he has to pay the damages.
Let him, my lord, show. And one more thing, my lord, before my learned friend commences.
Yes.
He is a company registered under the Companies Act. In his balance sheet and annual books of accounts, it will be reflected. One, illa andre bank statement.
Let us see what is that.
ಏನ್ ಮಾಡಿದ್ದಾರೆ?
How
Yes,
it has been paid
yes,
to you.
yes.
My lord, kindly, this memo may be taken on record, my lord, where we have mentioned, my lord, after the passing of the interim order, admitting and granting interim order,
Yes.
over and above the, my lord, the whatever calculation we have paid, my lord, 1,76,911.
What is the rent you are paying?
My lord, there is a slab, my lord, a breakup, my lord, we have given it.
No. What was the rent which has been fixed for that?
My lord, initially it was 2,244. Kindly see at Penex.
The method you are adopting for payment, how you have paid this amount?
It is not paid, by the way.
Wait, let
No,
him
no.
show that. Document has to be there.
So, ಏನಾದ್ರು ತೋರ್ಸು.
How it has
My
been
lord,
paid?
my lord, kindly see page 2. This is the payment made, my lord, on 2/10/2010, 1,76,000, my lord.
What, through what, mister?
This is through check.
Where is that?
My lord, they have applied for bank statement, my lord, that is not, my lord, made available. My lord, and on 29/6/2012, 2,23,325. My lord, total 4 lakhs has been already paid. And remaining, my lord, that 1,08,832.
This is,
Yes.
court has passed an order in wait.
Sorry.
2015,
My
after
lord,
2015.
my lord,
we are asking.
the submission is this, my lord. Over and above what is supposed to be deposited, we have paid already. Therefore, my lord.
No, 2015 court has said you pay regularly that rent as a damages for occupation.
I'm little
After
handicapped, my lord.
2015, nothing has been paid, mister. After, see, all is 2010, 12